Welcome to the Police Roll Call channel. I am Dennis Marsili, former Detective Sergeant, the City of New Kensington Police Department, New Kensington, Pennsylvania, former Director of the Criminal Justice Training Center at Indiana University of Pennsylvania, and currently adjunct Criminology Professor at Carlow University, Pittsburgh, Pennsylvania. The goal of this channel is to explain court decisions to assist police officers in enforcing the law in the field. The court decision I will explain is Commonwealth v. McMaster, Superior Court of Pennsylvania, June 2024, PA Super 130. Here are the facts of the case. On December 7, 2022, at 3 p.m., Conewago Township Police, Adams County, Pennsylvania, were called to a residence in their township for a report of an unclothed male subject screaming in the backyard of a neighbor. Prior to arrival, Officer Ammerman was advised by dispatch that the male had moved to the roadway in front of the neighbor's residence. Upon arrival, Officer Ammerman approached the naked male, later identified as the defendant, McMaster. The officer described McMaster's behavior as incoherent, excited, jumping around, and appeared to be under the influence of controlled substances. Based on these observations, Ammerman placed McMaster in handcuffs and called for an ambulance. For proper medical treatment, Ammerman asked McMaster what controlled substances he had taken. McMaster, still appearing incoherent, but eventually stating he had consumed ketamine and had huffed butane gas. McMaster's residence was identified for police as being near the caller's residence. Detective Bevenauer of the same agency arrived on scene and went to the rear of McMaster's residence, in which he observed a doorway to an exterior porch and a doorway into the residence through the porch were both open. From outside of the porch, Detective Bevenauer observed that the inside of the house appeared to be in disarray, and there were items thrown on the floor and trash everywhere. He also observed a butane lighter on the ground outside of the rear porch. The detective asked McMaster if anyone else was inside the residence. Detective Bevenauer was concerned there could be another victim suffering from a potential overdose or medical emergency inside the residence. McMaster did not provide a response. Based on Detective Bevenauer's observations of McMaster and his statements of what he ingested, and the thought there may be others in the residence in which McMaster gave no response, the detective decided to conduct a protective sweep of McMaster's residence. While inside, the detective observed in plain view suspected controlled substances, drug paraphernalia, and a mushroom growing operation. A search warrant was issued, and numerous items of suspected controlled substances and drug paraphernalia were seized. McMaster was subsequently charged with manufacture or possession with intent to manufacture a controlled substance, possession of a controlled substance, possession of drug paraphernalia, disorderly conduct as a misdemeanor of the third degree, and indecent exposure as a misdemeanor of the first degree. Officer Ammerman recorded the entire incident on his body camera. The recording was marked as a Commonwealth Exhibit 1 and entered into evidence. During the suppression hearing, the court reviewed the footage and found the testimony of Officer Ammerman and Detective Bevenauer as credible. Here's the roll call question for this week. What are the exceptions to the search warrant requirement? And I will provide the answer to that question at the end of the court brief. So here's what happened with the McMaster case. McMaster filed a motion to suppress the evidence, namely his statements made to police and any physical evidence obtained from the searches of his residence. The court granted the motion in part and denied the motion in part. Specifically, the court denied suppression of McMaster's statements but granted suppression of the evidence seized based on the initial warrantless entry into McMaster's residence. The Commonwealth attorneys, to their credit, appealed the lower court suppression ruling to the Pennsylvania Superior Court. The brief submitted by the Commonwealth attorneys argued that the actions of the police were supported by the protective sweep doctrine and cited two previous similar cases as precedent, Commonwealth v. DeVito, and Commonwealth v. Capel. Both cases involved reliable reports of domestic violence in which officers were not immediately able to locate any potential victims, and in both cases, officers made entry into otherwise restricted locations to search for additional victims. In each case, officers did not find any victims, but did find evidence of other crimes, evidence which was eventually seized under the authority of search warrants and admitted into court against each respective defendant. So the court in McMaster, after taking into consideration the totality of the circumstances, agreed with the Commonwealth attorneys and overturned the lower court suppression of the evidence, therefore justifying the protective sweep conducted by Detective Bevenauer and allowing admission of the evidence seized. Now to answer the roll call question. Here are the exceptions to the search warrant requirement: search incident to arrest, plain view, smell and feel, abandoned property, the limited automobile search, consent searches, inventory searches, and exigent circumstances with probable cause, which include emergency aid, prevention of the destruction of evidence, and hot pursuit. That's the overview of the Commonwealth v. McMaster case. If you like this video, please subscribe below to watch other court decisions. Thank you, and thank you for your service.